Hello and welcome to Higher Results, where business, workforce, and talent intersect. I'm Melodie Reagan, the CEO of Eye to Eye Workforce and your host. On Higher Results, we cover all things HR throughout the life cycle of a worker as well as you and your career. And today our topic is 1099 versus W-2, the do's and don'ts and when to use what. And of course with us we have our business attorney with us, Justin Vaughn. So I'm going to jump right in. Justin, would you please share with us a little bit about your background?
Sure, and Melodie, thank you for having me. I always appreciate the opportunity to visit, so thank you for that. I've been an attorney for 25 years. We do primarily business representation for closely held business interests and work with business owners on an ongoing basis on employee issues, as I know you do as well.
You know what, Justin, it's always a ball to have you here. I just love it. We have a great conversation. Well, I'm going to do a little bit of a setup for everybody. And part of our setup, in terms of the United States, I always find this fascinating, so everybody knows. In industrialized nations, only about half of your population works. We really don't realize that, but only about half. And when we're looking about workforce eligible, what's participating, it's a little 60 to 65%. Now, what is happening in the United States, think about it, we're about 311 million in our population, right? So about half of that is what is making up our workforce today. And what's interesting is by 2020, what we're saying is about 40% of that is going to be contingent. Contingent is 1099. What that includes is people working under contract, people who are temp, people are solopreneurs having their own business versus being on W-2. And when you're W-2, obviously you're getting a paycheck. The business is taking out payroll taxes and contributing to your payroll taxes versus you being an independent and getting paid on a contract basis. So what we're going to do today is we're actually going to delve in and understand the legal components of those relationships. So let's start this discussion with what is the legal definition of a 1099 versus a W-2 employee?
Sure, and as with any such categorization, there are the qualifications for that, and then there's the effect. The effect is, are you going to have taxes withheld as an employee, or are you going to pay self-employment tax as a 1099? The criteria is set up, and there can be different criteria in each state, but the criteria is set on the federal level, and the IRS has publications on their website that identify it. And in broad strokes, the IRS says that if you're controlling how the work is performed and specifically defining what work is performed, then you're more likely categorized to have employees rather than an independent contractor. But if you define the result desired of the work, but you don't control the what and the how of those work components, then you're more likely going to be considered by the IRS as a 1099 relationship. So the independent contractor relationship, of course, is set up by contract, hence the title, hence the name. If you're looking at state law here in Colorado, and again, it can differ in each state, but under state law, you have factors that are set up by statute. So if you have a written contract and you meet those factors by statute, in other words, the primary company is not intertwined with the other company, they're treating them as independent, they're doing work for others, they're not supplying the materials or the computers, the equipment, what have you.
Training.
The training, other than just minimal training, they're not providing extensive training. And it's not an exclusive relationship where they're requiring you can work only for them. Minimal oversight, minimal instruction, those types of factors. And you have those in a contract, and that's been put into writing, then you overcome the presumption of an employee and you can be classified as a 1099. It still depends on the whole circumstances, and the IRS has a 20-factor test to look at. Colorado has the statutory components and some case law components, so you just look at the totality of circumstances, but the main issue is, what is the extent of control? Does it truly look like an employee that you're telling them what to do and how to do it? Or does it truly look like an independent contractor, somebody who provides those services for others, and somebody who's providing those services for your company?
So that's from the employer perspective. The other part to this, though, is very much what is going on from the tax perspective. So if it is a W-2, and it really is defined by the IRS, this is where these terms originally come from, right?
Right.
If it is a W-2, it means that the employer is giving them a paycheck, taking taxes out, and that they share in that tax burden for the worker, but the worker's paying it. So it's not just the employer, it's something that everybody pays for. And there are different laws around W-2 workers versus 1099. A 1099 can be an individual that you are bringing in using their social security number, or you can require that they have their own business and be an LLC. They can still be a solopreneur, but they have to pay taxes. So they're the ones that are paying taxes. You're just paying fee for service. So that's the financial component, right? Now I want to talk about contracts for each.
Well, to add on to what you just shared, you also, under the state provisions, if you're an employee, then you're eligible for workers' compensation coverage. You're eligible for unemployment if the employment ends.
That's right.
Independent contractors are not eligible for that. And that's why if employers get that categorization wrong, they can be exposed to not only those types of obligations,
Right.
but also the penalties for getting it wrong. So it is very important. And I'm sorry, repeat your last question.
Well, actually, even before we go there,
Sure.
with what you just said, which I love that you brought that up, that you have access to. So as an employer, if you're going to have W-2 workers, you have to have workers' comp. That is by law. You'd be silly not to have it, right? So what you're talking about, and then having access to unemployment insurance. Access is one thing, getting it is another. You know, it's saying, same thing with workers' comp. It's not just there for somebody. In terms of getting unemployment, if somebody's terminated for cause, well, guess what? That changes your eligibility for unemployment. So it is a relationship. So two fantastic
Absolutely.
points, two
Absolutely.
really important points for employers. So when we have employees, we have to have both of these. And I go a step further. I'm really big on also professional liability. So I have additional insurance just to cover us as a business as we're providing services, but not required. Now, let's talk about contractual relationships, because with anything, you have some kind of a relationship and some kind of a contract. So let's start with talking about our 1099s.
Sure.
Should we have a contract? Can I do it with a handshake? What do you recommend?
You should have a contract every time.
Yeah.
Every time. You want to be able to prove to the IRS that is the nature of the relationship. You want to be able to prove if somebody is requesting sanctions or claiming that they're an employee. You want to be able to prove the nature of the relationship. And most importantly, under Colorado law, if you don't have a written contract, then they are presumed to be an employee. And you have to overcome a fairly significant hurdle to prove otherwise. So you always want a written contract in terms of your relationship with an independent contractor. And if it is a true independent contractor relationship, then all the more reason why you want a contract that defines that relationship, their obligations, your obligation to pay, how that relationship can come to a conclusion. All of those things should be set forth in writing, absolutely every time.
By the way, and so everybody knows, that is referred to as an independent contractor or consultant agreement, if you were to go look it up online. The other thing about that contract, it establishes the relationship between you and that contractor. You also need to have something about the scope of work. So it's not this unlimited or where they're doing anything. Make sure that you are defining the relationship. What is the scope of the work? What are you paying them? What are the terms? Confidentiality, other things that you need to concern yourself with, which we're going to get to in just a minute, has to do with IP. So
Sure.
Let's actually talk about that, and let's stay in the path of the 1099. You know, one of the things that we are always concerned about is confidentiality. We're concerned that if somebody creates something, who owns it, right? Who has the IP on it? So how do you go about handling that with a contractor? Absolutely,
and generally, although you can do a separate agreement, but generally that should be addressed within the independent contractor agreement or advisor agreement. It should be addressed who is going to own the IP that is developed, who has licensing rights, who has trade secrets that are protected, and sometimes those trade secret protections go both ways. So you want to make sure that you define that so that there isn't litigation later on, and that's of course our primary objective, at least from my perspective, we're trying to avoid people suing each other later on, so we want to define it, and we want to say who has those rights, particularly with regard to the IP, as you mentioned, particularly with regard to trade secrets, because you don't want to disclose to an independent contractor how you do business, what business you do, who your clients are, all of the otherwise trade secret information, and then have them go off and provide that to others, or set up their own business to take away yours.
By the way, that is one of them, as the agreement should have a component of it that speaks to those trade secrets. The other thing that I talk to independent contractors about, let's say that in the course of you doing the work, because your customer, because it's truly a customer, you do not work for them, your customer is paying you to deliver a service. If you use some proprietary copyrighted system, process, information in the process of delivery, you need to make sure that that's clearly marked, that it's clearly marked as yours, because I can tell you most of the agreements are going to say anything that you do for that company, the rights for what gets created is conferred on that company, not on the independent contractor. So as far as a comment, if you are using something and you want to protect yourself, make sure that you are clear about what you're using that is already owned by you.
And the same with trade secrets.
Yeah.
What you own by way of IP, what you own by trade secrets. Couldn't agree with that more. To add one other component, it's also helpful to have not only the non-disclosure language for trade secrets, but also non-solicitation language, meaning that the other company cannot solicit your employees, cannot solicit your customers or clients. There are also circumstances where it's appropriate to have non-compete provisions. Colorado has recognized non-competes in the independent contractor context. It mainly revolves around protecting those trade secrets, so you have to have trade secrets to actually protect. You have to have a factual justification.
That's
it has to be reasonable in scope, and you have to meet all of the criteria.
Yeah.
But you can include, and in certain circumstances, absolutely should include such language in an independent contractor agreement as well.
By the way, very important. It's very important to protect both parties. Now, let's jump over to employees. What is the legal relationship and what kind of contracts, or what makes up what is a contract with an employee?
Well, it depends on what category you want to put an employee in. There are employees who work according to contract terms. We see that most often in terms of C-level executives.
Right.
There are, for everyone else, they are categorized as employees as well. And that's a term that we're generally familiar with, but it means that that employment relationship is at the will of either party. There is no involuntary servitude in the United States, so employees get to leave, employers get to terminate employment, and that's an employment at will context. If employment is defined according to a contract, then it's enforceable according to the terms of that contract. So there might be severance terms, there might be change of control agreement provisions, there could be other benefits provided, but it's determined according to that contractual relationship. If an employee is at will, then those terms are subject to change at any time, because of course you can terminate employment at any time.
By the way, that's one of them. When you think about at will, honest day's pay, what I tell everybody, for an honest day's work. An employer actually doesn't owe you notice, and you don't owe them notice. Those are what we call professional courtesies, where somebody gives you a 2-week notice. And it's good because obviously you want references and you want to have great relationships, and not every employee is going to stay with you forever, right? People have careers and they go on. Although any of my employees watching this show, please stay with me forever.
They will. They know better.
So
the grass is not greener somewhere else. Don't even think that.
But it is truly, it's an at will that everybody has and where they have courtesy. Now, there are things with an employee that you do have to put into a contract, and I do recommend it, but there is something that is a requirement in terms of relationship. It's not necessarily a contract, but let's talk about how an employee manual fits into this and why you should have one.
Sure. I think an employee manual has a few benefits. One is it can really present your company well to onboarding employees. And it should reflect that. It should reflect the culture. It should reflect the values and the vision of the company. One of the other important components, it can identify the expectations. It can define the expectations in terms of, when are wages paid? What are the vacation policies? What are the benefits that the employees are going to see? And it's not that that's necessarily locked in. It is subject to change, but at least it gives expectations on an ongoing basis.
Do you know what I relate that to? Before I say that, I relate that to, like on a website, you have terms of service and a privacy policy.
Sure.
They're there, you're using it, it's subject to change, and depending, you should notify people. Employers should notify your workers when it is changing, just like major changes on terms of service and privacy policies.
Absolutely. And all of those internal policies, dress codes, and we could go on, but exactly, that's exactly right. The third important purpose of an employee manual is to address items that are provided under federal law, under state law, particularly non-discrimination policies, harassment policies, avenues for correction, all of those things that we've talked about before. And then I think those are on your website, so if anybody wants to find out more about those policies. But then if you have somebody who does complain to the EEOC, and of course you wouldn't, but those types of things occur, then the EEOC will want to see a copy of your employee manual. Are you putting forth, are you espousing those policies that the EEOC requires under federal law?
Very important.
Is the NLRB going to investigate you, and do you have social media policies and all of the things that the NLRB wants to see? So compliance with that and having a manual that really is up to date, reflects current issues under federal and state law, I think is critical.
By the way, it is really important. A lot of firms, when you're running rapidly, you don't do an employee manual. But if you're going to hire W-2s, you need to have that employee manual because it totally gives you what the policies are, as Justin has stated. So don't let that get by you whatsoever. Now, the employee manual, exactly with what he said, it covers components. But let's talk about IP and how IP with workers works and confidentiality. So what do I have to do as an employer to make sure I'm maintaining confidentiality and that what my workers are creating is owned by me?
Sure, and there are a couple of things. There are a couple of things you can do for that. One is what we alluded to before. You can have non-disclosure agreements, non-solicitation agreements that say those trade secrets stay here, you don't get to take them with you, you don't get to go to a competitor or become a competitor and use those trade secrets. So you can have that kind of restriction against competition and against disclosure. The other, specifically to IP, is a proprietary inventions and information agreement. So a PIIA, as it's called, is basically an assignment that an employee signs that says, if I create anything that falls at all within the course and scope of employment, then that belongs to my employer. And those types of agreements, and you can merge those with non-solicitation and trade secret language, but those types of agreements are fairly common. If somebody is going to do something specific that is separate and apart, best to talk to the employer and have a carve-out for that, from that agreement. But otherwise, if anybody has an invention, if anybody creates a new formula, new approach, new procedure, whatever it may be, if it's something that is arguably proprietary, then that agreement places the ownership with the employer, and again, creates a clear understanding and therefore hopefully avoids litigation.
By the way, there's a clear understanding, but with employees, you definitely have a baseline that the work that you're doing for the employer is owned by the employer. However, by having these agreements, it actually takes you to that next level where it removes all ambiguity. One other one that I want to ask about with this, because I think about employees, is job descriptions. Because we're talking about all the contracts between 1099 and W-2. What's the purpose of a job description and why might this be relevant legally?
I think job descriptions actually are one of the most overlooked but important documents for employees. The reason it's overlooked is An employee comes in, they're told, here's what you're going to do, here's how you're going to do it.
Right.
And people think, well, I don't need to write down what you're supposed to do. You know what you're supposed to do. And you're seeing the person next to you doing that, so just do what they do. So that's why it's very easy to overlook job descriptions. The problem is for employers. The problem is the current law concerning the Americans with Disabilities Act. It was established in the 90s, amended in 2011, and what that says is if somebody requires an accommodation because they have a disability, and a disability is defined as some condition that is not experienced by a majority of the population. So if they have some condition that warrants a disability and they assert a claim for reasonable accommodation, and you have nothing in writing to look at to say, here are your essential job functions. And if that goes to court, which they occasionally do,
Yes.
It's not by the happy employees, it's the disgruntled employees who are generally taking that to court, and it's in front of a judge, then a judge is going to say, well, I have nothing in writing that identifies the essential job functions, so why didn't you grant this accommodation? And the employer is at a disadvantage under those circumstances. So we've seen situations, we've seen cases
Yeah.
where somebody says, I have sleep apnea, I want a 2-hour break in the morning and a 2-hour break in the afternoon, or what have you, and perhaps it's a receptionist position. Well, of course, that's very difficult for an employer to have somebody who's absent, and
Yes.
they have to figure out how we're going to do that. And if you have that in your essential job functions, that somebody be physically present, I know it sounds kind of simplistic, but if you have the essential job functions that say, here is the job, here is what you have to do in order to do it,
Yeah.
you still have to perform an evaluation of any request for reasonable accommodation. You still have to take those things seriously,
Fantastic.
but at least you have the foundation to determine.
Excellent.
Yeah.
Well, you know what? This has been, as always with you, Justin, another very insightful discussion.
Thanks.
So if you're thinking about 1099 or W-2, of which the majority of businesses today, we actually use both. Make sure you're prepared with all of the right documentation to ensure your operations run as effectively as possible. So if you missed the show, no worries. You can get our shows on i2iworkforce.com. You can also get it on IPTV Now, which is our host. And you guys, we air every Tuesday at 3 p.m. Mountain Time. Please join us again. We're on facebook.com/our results and facebook.com Innovation Pavilion. Thank you so much for being with us today, and we'll see you next Tuesday.